All right, everyone. Go ahead and get started and let everyone kind of get in. 9:01. Good morning. My name is Deandra Coleman. I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia SBDC is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses and their local communities. Our one-on-one counseling consulting services are available at no charge. Today's webinar, Intellectual Property 101, is presented by the Virginia SBDC in collaboration with the United States Patent and Trademark Office, and is the first in a series of 4 webinars covering patents, trademarks, copyrights, and trade secrets. Before we get started, I just want to mention a couple of housekeeping items. We are recording today's presentation. It will be posted on our website, virginiasbdc.org. Due to the large number of participants in today's webinar, everyone's microphone is muted. If you have questions during the presentation, you can type those into the Q&A box, and time allowing, our presenter will answer them at the end of the presentation. Today's presentation will be given by Elizabeth Dougherty, who is the Eastern Regional Outreach Director for the USPTO. She carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, and is responsible for leading the USPTO's East Coast stakeholder engagement. Ms. Dougherty ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. She has more than 25 years of experience working at the USPTO and has developed, implemented, and supervised programs that support the independent inventor community, small businesses, entrepreneurs, and the intellectual property interests of colleges and universities. Similarly, she has spearheaded a number of special projects with federal, state, and local governments and private organizations to promote and support invention and innovation in the United States. And now I'll go ahead and turn it over to Elizabeth. And if you can say your last name for me, because I believe I missaid it. Of course, you told me how to say it.
No worries, Deandra. Thank you so much. Let me start today by thanking both Deandra and by thanking Amanda, our 2 wonderful Virginia SBDC hosts today. It's a pleasure for the U.S. Patent and Trademark Office to collaborate with the Small Business Administration and specifically the Virginia SBDC. We love to work within the communities, within the states, and we recognize that our federal partner at the SBA is one of the greatest ways to do so. My name is Elizabeth Dougherty, and she, in fact, didn't butcher it, but that's quite all right. Call me Elizabeth, call me Liz, call me Eastern Regional Director, call me whatever you'd like. I'm excited to enter your home from my home and to talk to you today about intellectual property. As Deandra said, this is the first in a 4-part series, this being part 1 of 4. And I hope today that I am going to whet your appetite to participate in the next upcoming programs. The next program following my program is going to be a program this Friday on patent basics. So hopefully today, by talking to you about the various forms of intellectual property, patents being one of them, you're going to be just that much more curious to learn more about patents. Next week, we're going to talk about protecting apps and software, protecting the intellectual property of apps and software, recognizing that this is a topic and an area of innovation that many of you are pursuing at this point in time. And then last but not least, next Friday, the following Friday, Friday the 11th, we are actually going to hit on trademark basics. And trademarks, for those of you who don't know, are oftentimes the most valuable form of intellectual property and something that is perhaps pertinent to each and every business, no matter whether you're a nail salon or creating a startup tech firm. Trademarks are your friend and trademarks are important. But before I jump into my materials, and I do have a lot of materials, I do want to give a special shout out to our host, Amanda Jarvis, because she and I share a very special thing today. It's both of our birthdays, and we're spending our birthday with you. Now, I was instructed that I was to wear my birthday tiara during today's performance, but I think I'll wait and hold off until maybe the Q&A portion, if that's okay. But happy birthday to Amanda. And again, I'm excited to share my birthday with all of you. With that, I am going to go ahead and begin to share my slides. Again, I have a great deal of material, so we're going to go through it pretty rapidly. But again, I'm hoping that this is going to really whet your appetite to learn more. My contact information is at the end of the slides, and I welcome you to reach out to me after this presentation, either through my email or through LinkedIn, where you can find me as well. But with that, let's go ahead and get into the fun. All right, so here we go. As Deandra and Amanda have both said, this is a collaborative programming effort between the U.S. Patent and Trademark Office and the Virginia SBDC. We're happy to bring this information to you because it is critical information for those of you who already have a small business or who are looking to start and build and grow a business. Intellectual Property 101 is our topic today. We're going to talk about the importance of intellectual property. What is it? Why is it important to you? And then what are the forms of intellectual property, and what are some of the resources that are available to you? So you may be saying to yourself, okay, I've come to this class, and let me congratulate you for doing so. I want to congratulate you for giving yourself the gift of education, especially during these challenging and uncertain times. This is a great time to take a step back and figure out how to enhance your business, or perhaps to start that endeavor that you've held off on starting. Why is intellectual property important to a business? It's important to a business both at the 30,000 foot level and at the individual level. Taking the 30,000 foot level though, IP intensive industries are critically important to the US economy. IP intensive industries, though it's industries that possess intellectual property, whether it's patents, trademarks, copyrights, or trade secrets, they provide 45.5 million jobs. They also provide an enormous wealth into the nation and produce jobs that have higher pay. Now, when I say IP is critical to a small business, it's because it becomes a component of your business. It makes your business more attractive to investors and buyers. It can deter infringement lawsuits by putting it out there in the public that you have protected your intellectual property. It can increase your leveraging power, and it's a property right. It's a property right just as a real property right. It can be bought, it can be sold, it can be licensed, it can be given away. So it is a value add to your business. So why does invention matter, and what does it mean to you? Again, on the individual level versus the 30,000 foot national economy level, invention promotes innovation and helps safeguard your inventions. It helps your company grow by continuing to invent, by continuing to innovate, by continuing to modify your business. You can help become relevant to your clientele. You can become that next greatest thing, and it benefits the community by making new goods and services available. It also provides personal growth, development, and advancement by saying that, again, by continuing to revamp, by continuing to refresh and renew, it keeps you there in the forefront of people's interests and people's buying opportunities, and it keeps you relevant to the community. So what is intellectual property? Very simply, intellectual property is property of the mind. It is property that is created in a creative fashion by your intellect, as the name suggests. Now, this is in opposition to real property. Real property is that house you may own, that car, that boat. Now, it has a similar complexity to real property, and you'll see when we talk about intellectual property, there is some complexity involved. And again, I make the analogy to real property. Think about the last time you bought a house or a car or a boat. Think about how many times you had to sign on the dotted line. Well, intellectual property, because it is the receipt of a property grant from the federal government, there are some complexities involved, but the U.S. Patent and Trademark Office and the SBDC is there to help you walk through this process. So the types of intellectual property, and I apologize that I feel like I'm speeding through this information, but I want to make sure to get through all of it and to have time to answer your questions today. So we're going to keep plowing through. The four basic types of intellectual property are patents, trademarks, copyrights, and trade secrets. They are each very different forms of intellectual property and protect very different things. As the name suggests, the U.S. Patent and Trademark Office helps you to protect patents, or new and inventive ideas. It also helps you register trademarks which serve as the identifier of the origin of goods or services. Copyrights protect creative expressions stored in a tangible form. And that is done by the US Copyright Office, which is part of the Library of Congress. Trade secrets are covered generally by contract law, by a business employer to employee relationship. So these are generally covered again by contract law and not covered by any specific agency, although the US Patent and Trademark Office, as the nation's intellectual property office, we do provide guidance, recommendations, and policy work with respect to trade secrets and copyrights as well. So just to give you a snapshot of the US Patent and Trademark Office, because as I like to say, good or bad, we are the best kept secret of the federal government. We all live the lives we do because of patented technologies and trademark registered goods or services. I like to say that we would not recognize the lives that we lead without patents and trademarks, but yet your average American, perhaps, in all likelihood, doesn't know what the US Patent and Trademark Office is. Now, this data is about a year old, but I felt it was important to just give you a snapshot into the USPTO. And for those of you, and I think the majority on this call are in the Virginia area, the headquarters for the US Patent and Trademark Office is actually in Old Town Alexandria. So very close by for those of you living in the state of Virginia. We are an agency of almost 13,000 employees, and each year we receive over 600,000 patent applications. We receive over 600,000 trademark applications. So when you ask, how long is it going to take for me to get my patent or to get my trademark? Let's keep in mind the volume of patent applications and trademark registration applications that are being filed each year. Now, I like to say that as a positive because it reflects the number and the great wealth of creative endeavors that are taking place, that over 600,000 individuals and companies have come up with something that they think is worth being protected by a patent, and of course being protected by a registered trademark as well. But just to give you that snapshot, again, we're a large federal agency. We are part of the Department of Commerce and are headquartered in Alexandria, Virginia. Now, we do have regional offices in Detroit, Denver, Dallas, and San Jose as well. Let's start with trade secrets, and we're going to work our way back into patents. Patents will be the last topic that we hit, but let's talk about trade secrets. Most of when you think of a trade secret, and if you're familiar with the concept of a trade secret, probably think about something like KFC. What are those, that recipe for making that chicken just so good? Those, I think they have 7 individual spices. Again, I obviously don't know because they've kept it as a trade secret. The Google search algorithm is also a trade secret. So as you can see from those 2 examples alone, trade secrets can cover a great deal of differing material. Trade secrets, very honestly, can be anything that brings value to a business that can be maintained as a secret. And that secret is really the key ingredient of the trade secret. You have to be able to maintain, and you have to take steps to maintain this item as a secret. So how does one do that? One does that again through things such as contract agreements with your employees. They pledge, they assert that they will not disclose the secret. You may split the secret up amongst employees. It's said that at Coca-Cola, now this may be completely anecdotal and may not be true, but they say at Coca-Cola, not one individual has all of the recipe ingredients for making Coca-Cola. Is that true? I don't know, it's a secret. So again, it can be something as simple as a customer list. It can be, again, a search algorithm such as Google. It can be the way the machine parts work or the way the machine is assembled. It can be anything that your team, you and your team, can keep as a secret. So ways to lose a trade secret. As I said, the secret is the key ingredient. Failure to take adequate steps to prevent disclosure. This is, you don't tell your employees that it's not okay to go home and talk to their family and friends about what the secret is of the company, how to make Coca-Cola, how to make that chicken. Owner or owner authorized disclosure, and it happens all of the time. Reverse engineering, and this is one that I think is particularly worth touching on. if you've come up with a invention, and let's go with invention, and it is something that others can quickly figure out how to make and use, and perhaps build it themselves without your knowledge, then they can reverse engineer. If someone can pick up your invention and figure out how it works, how it operates, how to build that, then it's probably not something that is best kept as a trade secret. If it's apparent to the naked eye, if it's apparent to the general public, if there is no way to keep the maintenance and the operation and the development of that, if again, it can be reverse engineered, if somebody can actually backtrack from your invention to develop it themselves, then it's probably not best kept as a trade secret. And then of course, independent development. People oftentimes come up with the same idea, the same invention. And we'll talk about that more specifically in the area of patents. Let's move on to copyrights. As I said, copyrights are issued by the Library of Congress. Although copyrights are super interesting in that copyrights are what we call self-authenticating. By simply making the creative work and placing it in a fixed medium, you in fact have obtained a copyright. Now you are encouraged to register your copyrighted work with the Library of Congress, because that provides you with additional rights and additional means for going after someone who perhaps violates your copyright. So again, these original works of authorship, just like trade secrets, covers a wide range of things. They can be literary works, dramatic works, musical, artistic, and certain other intellectual works, things such as sculptures. I think oftentimes we think of this in terms of movies or in terms of books or music. And that's certainly items that are protected by copyright. And so where we hear the context most often. Interestingly, the term of a copyright is the author's life, the creator's life plus 70 years. Thus, not only does the creator, but their heirs get to benefit from this creative work, which has been protected by the copyright. Now, to take a step back, and to talk about trade secrets, and I failed to mention this. When we talk about the term of a trade secret, this is where it gets really exciting. A trade secret can last forever as long as it's kept as a secret. So remember again, that secrecy is the importance. So a trade secret can be extremely valuable if the material can be maintained as a secret. So back to copyrights, again, it's an original work of authorship. And it is done by the Library of Congress, and it is the author's life plus 70 years. Things protected by copyrights, as we said, songs, movies, books, sculptures. So moving right along to trademarks. And again, our fourth presentation on December 11th will be about trademarks, and I hope you'll tune in then, but let me tell you a little bit about trademarks, because I think you're going to want to know more. So what is a trademark? A trademark is any word, slogan, symbol, design, or combination that identifies the source of your goods or services. It helps to distinguish them from the goods and services of another party. Let's take a simple example. A friend calls you up this afternoon and says, "Hey, can I buy you a Big Mac?" A Big Mac. How do you know what a Big Mac is? How do you know where a Big Mac comes from? Well, a Big Mac is a trademark that is owned by the McDonald's Corporation. And it is an identifier of the source. It identifies that that hamburger patty sandwich comes from McDonald's. And it also, because we've grown in the understanding of what their trademark protects, we also recognize that it's 2 all beef patties, special sauce, lettuce, pickles, onions on a sesame seed bun. It provides an indicator for individuals to know what your product is and to encourage them to go back to your product. Again, it distinguishes them from the goods and services of another party. If somebody offers to get you a Big Mac this afternoon, you aren't expecting them to arrive at your house or your home or wherever you're meeting in the park with a fish sandwich, because the trademark Big Mac has identified the source of the goods, and it has also allowed you an appreciation of what has been created by that rights owner. Some simple examples of trademarks outside of Big Mac: Starbucks, Nike, Target. Now keep in mind, a trademark can be many different things, as we saw on the previous slide: a slogan, a symbol, a word, a design, or a combination. So oftentimes you'll see a combination. It could be a word and a design. On your Starbucks cup, you might see the picture of the mermaid as well as the name Starbucks. On your shoes, you might see the Nike swoosh and the word Nike in the tongue of your shoe. At the Target store, you're certainly going to see the bullseye and the name Target. Now, the fun thing about trademarks, well, there's a lot of fun things about trademarks, but some of the really fun things are there are some very non-traditional trademarks. A color, in fact, can be used as a trademark. Think about what can brown do for you? Just by saying that slogan, you probably know I'm talking about UPS, but also when that brown delivery truck drives up in your driveway, you don't look out the window and say, "Oh, Mom, FedEx is here." You know the UPS driver is there. Those green ubiquitous tractors that we see across the nation, John Deere. And then of course we have our Tiffany's blue box. Ladies, who doesn't like to see one of those under the Christmas tree or on our birthday tray? Non-traditional marks also include scents. For anyone who's ever opened a can of Play-Doh, you certainly know it's Play-Doh, even if your eyes are closed. And then, of course, there's also some non-traditional marks that are sounds. The NBC chimes, the Pillsbury Doughboy, that little giggle that he has when somebody pokes him in the belly. You know that even without being able to see the commercial or without being able to see the picture of the Pillsbury Doughboy, if you just heard that giggle, how many of us would recognize, oh, that's the Pillsbury Doughboy. It must be that commercial for their cinnamon rolls that's always on about this time of day. So there is something called a common law trademark. And this is something that I'm going to have my colleague Craig Morris, who speaks to you on Friday, December 11th, speak to you more about. But this is something that is not registered. And this is something one obtains by merely using your identifier, your word, your design in commerce, but without registering it with the US Patent and Trademark Office. Now, is this the way to go? Certainly it's a great first step, but we would encourage you as the US Patent and Trademark Office to federally register your trademark with us, because you're going to find out through Craig's lecture that there are a number of additional benefits by registering your trademark. And here are some of them right here. Public notice of claim of ownership, legal presumption of ownership. As you can see, and I won't read these all to you, but one of the ones I would like to point out to you is listing in the United States Patent and Trademark Office's online databases. When somebody starts a business or considers developing a trademark for their business, they should always conduct a trademark search, because maybe your slogan, your word, your design is just so clever, someone has already thought of it. So you should do some searching, because you do not want to infringe on someone else's trademark. So you want to make sure that that trademark is available for your use and your use only. So by having your trademark registered with the US Patent and Trademark Office, it places you in our online database, which is really one of the first places that people look to see if a trademark is available for their use. The last point is also a particularly strong one. You may take your trademark registration and record it with US Customs to prevent importation of infringing foreign goods. By registering your trademark with US Customs, they are going to help you prevent the importation. They are going to help you at the borders. They are going to help you at the ports, prevent the importation of infringing products. So how does one get a trademark? And again, this is going to be something that Craig goes into in much greater depth. The two great considerations are marks confusingly similar? Is there a likelihood of confusion? So when a trademark examiner at the US Patent and Trademark Office sits down with your trademark application, they're going to look and see if there are other existing marks that could cause confusion. Is there a confusion for the consumer if we were to issue that mark? So let's say, for example, going back to our Big Mac example, what if somebody came up with a hamburger called the Big Snack? The Big Snack burger that's being sold at a competitor's location. Is that mark confusingly similar? Does it look like the Big Mac symbol? Does it look like the name Big Mac? Does it sound alike? Does it have a similar meaning? And are the goods or services related? Now, if somebody were to name something Big Snack, and perhaps it was a bag of popcorn. Now, Big Snack and Big Mac still sound alike, So there is that confusingly similar sound alike, but are the goods and services related? Is a bag of popcorn and a burger enough related? Are those goods related enough that we should not issue that trademark? Well, I can't give you that answer. That answer is only one that could be given by the trademark attorney who is doing the examination of your trademark application. But the goods and services related is a relevant conversation to have. I'll give you another example. Think about Delta. We know Delta is Delta Airlines, and we also know Delta faucets. Now, do the marks sound alike? Why, of course they do. Do they look alike? When written as a word, they do look alike. Now, when they're in their design, they perhaps don't look alike. But the real question here, the crux of this argument is, are the goods or services related? Would a consumer have a likelihood of confusion that Delta airplanes and Delta faucets are created from the same identifier? Not very likely. So again, it's a two-part consideration in determining whether or not to issue a trademark registration. And these are 2 points to be kept in mind as you are developing your trademark. Craig's going to talk to you a great deal about what makes for a strong trademark versus a weak trademark. Those fanciful, arbitrary are perhaps the strongest trademarks. And again, Craig will get into this in great depth. Fanciful or arbitrary are going to be things like Exxon. The word Exxon outside of petroleum services gas stations has no meaning other than the identifier of goods or services, gas and petroleum products. So a strong trademark. Now, he's going to get into telling you about the suggestive, descriptive, and generic. And I think it's going to be a very relevant conversation and one that I hope you'll tune into. Now let's talk patents, because I see we're already at 9:30 and I want to keep us moving forward. What is a patent? As I said, the U.S. Patent and Trademark Office issues U.S. patents and registers federally registered trademarks. So a patent protects those things that we think of as inventions, and it provides the owner of that property right, the opportunity to exclude others from making, using, selling, offering for sale, or importing the claimed invention for a limited term. Think about that copyright. That copyright was good for 70 years plus the life of the author. A trademark, and I failed to mention, a trademark is good for 10 years, but can be continually renewed if it is continually used in commerce. So a trademark, like a trade secret, could in fact last forever if it is continually used and continually renewed in 10-year increments. A patent, however, depends on the type of patent, but patents, general utility patents, which are cover the majority of what we think about as inventions, are good for 20 years from the date of filing. Now, this term has changed over time, but it is currently for utility patents a limited term of 20 years from the date of filing. Now, it's important to know that intellectual property is territorial, and it's spelled out here on this slide for patents, but it's true of all forms of intellectual property. Intellectual property only provides you protection in the country in which it is issued. So if you get a US patent, it protects you in the United States. If you are seeking to sell your product abroad, let's say, for example, France, you're going to want to consider seeking a French patent. There are at this point in time, and probably not in my lifetime, any worldwide patents. Oh my goodness, I apologize. The slide has certainly jumbled itself in its delivery to the Zoom platform. Let's leave it to say that there are 3 types of patent. Utility, which as I mentioned is good for 20 years from the date of filing, protects process, machines, articles of manufacture, composition of matter. Design patents protect the ornamental appearance of an article of manufacture and are oftentimes held in the same patent portfolio as a utility patent. Take, for example, the Apple iPhone. The Apple iPhone has hundreds, if not thousands, of patented technologies in that phone, both within the components in the phone, and then a design patent, which protects the ornamental appearance, the exterior ornamental appearance of that phone. And then, of course, there are plant patents, which protect any asexually reproduced plant, and those are also good for 20 years from the date of filing. For those of you who have never seen a US patent, I encourage you to visit our website. or even visit Google Patents and type in something that you're interested in learning about. This particular example is a computer system, and it just provides you with what the face of a US patent looks like. It provides you with the date the patent is issued, the patent number, the invention title, the name of the inventor, the filing date, any prior art that was applied by the examiner or supplied by the inventor, drawings of the invention, if the invention can be depicted in drawings, and an abstract, the abstract being mainly a short summary of the invention. So how do you know if your idea is eligible for protection? Because not everything is patentable. So one of the laws that governs patent applications and governs the issuance of patents is United States Code 35 USC 101, and that protects, that identifies and lays out what is eligible for protection. And that includes processes, machines, compositions of matter, and manufacture. Now, lay upon this, in order to be patentable, not only does it have to be one of these 4 classes of subject matter eligible material, it also has to meet the 3 criteria which are in the circle in front of you: novel, non-obvious, and utility. This is what a US patent examiner, when they pick up your patent application, looks at to determine whether or not to issue you a US patent. They look to see whether your invention, again, assuming that it fits within one of the 4 statutory classes of patentable subject matter, they look to see, is it novel? Is it new? Has it not been invented before? Is it non-obvious? Is it a non-obvious variation on something which already exists? And that's oftentimes a very difficult determination for a patent examiner and for an inventor to make. Now, your invention also has to have utility. Now, this is a pretty low bar. For example, let's say you've invented a new hat. Does a hat have a utility? Well, of course it does. It has the utility of covering your head and keeping your head warm and protecting you from the sun. So utility means that the invention has to have a purpose. It has to serve a purpose. So this just goes into greater depth of what I've just said. Novel, non-obvious, and utility. Is your invention new? Is it non-obvious? And would it have not been obvious to someone in that field? And does it have utility? And again, these are the determinations that that US patent examiner is going to make when they pick up your application. So what is not patentable? Remember, we had those 4 statutory classes of patentable subject matter. What is not patentable? You cannot patent natural phenomena. You cannot patent abstract ideas. So when somebody says, oh, I have an idea, well, the US Patent and Trademark Office does not patent ideas. Your idea actually has to be a little bit more concrete than a mere idea. Now, does that mean you need a working prototype? The answer is no, but it has to be more than an idea. I'll give you an example. I have the idea of creating a time machine because I would love to go back in time and meet Abraham Lincoln. Now, that's a great idea, and a lot of us would love a time machine, but I have no clue as to how I would make a time machine. So I can't patent my idea for a time machine because it is not a useful machine, manufacture, process, or composition of matter that can actually accomplish that task. So the path to a patent, certainly it starts with an idea. It may develop into a provisional application, although that's not required. If you wish to seek a patent, you will have to file a non-provisional patent application, and hopefully you arrive at a patent, which will be good for 20 years from the date of filing. Now, in our Friday class, this Friday, the 4th, my colleague Blake Tankersley is going to give you a great in-depth presentation on patents and how to apply for both a provisional and a non-provisional patent. This slide just tells you a little bit about each, but again, I'm going to leave that to Blake to talk a little bit more about, because again, I want to be sure we have lots of time for questions at the end. Leave it to say that a provisional patent application is really is an application that is maintained in confidence for 1 year with the office. It's something that allows you to get something on file with the US Patent and Trademark Office for a low cost and a low barrier of entry. And it allows you to begin to talk to others about your idea and use the term patent pending. However, it is only that non-provisional patent application that is going to be picked up by a US patent examiner and actually examined and can result in a US patent. So what does the process look like in applying for a patent? And again, Blake is going to talk about this in much greater depth. One files an application with the US Patent and Trademark Office, and those are primarily filed electronically. While you still can walk that application in the door, especially if you live in Virginia and are anywhere near our Alexandria headquarters, we strongly encourage, and the majority of applicants file that electronically. It begins down the examination path by being docketed to a US patent examiner who has a background that makes them best able to examine your technology, whether your technology is a bicycle, a cellular communication device, or a complex database. We are going to assign it to a patent examiner who has a background in that type of technology so that it receives the best and highest quality examination possible. This begins the conversation between you and the patent examiner. And in all likelihood, you're going to be using a patent attorney or patent agent, which is strongly encouraged but not required. And you're going to begin the conversation and collaboration, which will hopefully arrive at you receiving an allowed US patent. Now, not all applications issue as a patent. In fact, right now, we're somewhere between a 50 and 60% allowance rate. So right now, if you were to file a patent application, between 50 to 60% of our applications are being allowed as US patents. Some go abandoned, some go on appeal, some get refiled and reconsidered. But this is a process of communication and collaboration. And I say that because all too often people file a patent application, they get that first communication from a patent examiner, and they throw up their hands and they say, oh no, I'm done for, because the examiner has rejected their claims, they have objected to their specification, they've objected to their drawings, and it sounds very negative and it sounds very legalese because there is the application of laws and rules to your application. But again, the US examiner is there to assist you, as is your patent attorney or patent agent. Now, how long does it take on average to get a patent? On average, once one files a US patent application, it takes approximately 4.7 to 15 months to receive a first communication. This goes back to that point I made very early on that we receive over 600,000 applications each and every year. So when your application comes in, it is placed upon the pile of applications and assigned to that examiner in your technology area. On average, it's taking approximately 2 years for people to get a final resolution, whether that's congratulations, we're issuing you a US patent, or there has to be some other route taken. Let's talk about USPTO resources, because I think you're going to find these very valuable. And I want to make sure that you're aware of these, because at this point, you may be thinking, this is all very overwhelming. There's 4 types of intellectual property: patents, trademarks, copyrights, and trade secrets. I don't know which I need. I don't know where to get started, how to get started. This just seems very complicated, and it seems like it might be very expensive. And those are all realistic and legitimate concerns and thoughts to be having right now. I truly appreciate that. This is a screenshot of our homepage. And I'll bring several things to your attention here to make it easier for you to enter into our webpage, because we do have a great wealth of information available, but there's almost so much information available that it's hard to know where to start. I always encourage people to begin with our Learning and Resources pull-down tab. In the Learning and Resources pull-down tab, you're going to find easily digestible education for inventors, entrepreneurs, startup, kids, and teachers. You're also always going to find on our homepage a innovation journey, a story of invention and innovation from someone who has done it successfully. This particular image that is here was about the 3 women who created the first patented jog bra. The jog bra, its prototype is actually now in the Smithsonian Museum of American History. These ladies have been inducted into the National Inventors Hall of Fame and are a great story to follow. What is currently on our homepage today is actually a story about a young female inventor, Marissa Strang, who's one of my favorites. She invented at a very early age for an invention convention. She invented a pet drying system, which she patented. She got a trademark. She has a copyrighted website, and she is selling her product in the stores in South Florida and on the internet. It's called the Puff and Fluff. Look it up. It's one of my favorites. You'll also see in our toolbar on the bottom, we have access to our COVID-19 relief and support efforts. many of which are targeting small business. We also have our expanding innovation section, which includes information to help demystify the patent system, which is something we're doing today and something that Blake is going to help to do on Friday in his conversation. And then, of course, last but not least, finding direct resources in your geographic area. This is great. Now, again, for those of you living in Virginia, you have the USPTO headquarters nearby, although we're currently closed and closed to the public and only teleworking like many of you. But by going to this, finding the USPTO in your region, you can find state-specific resources. The pro bono program that's available in your area, the patent and trademark resource that's available in your area, et cetera, et cetera. So I encourage you, particularly if you're not from the Virginia area, to find what resources are in your area. So as I said, we do have regional offices in Detroit, Denver, Dallas, and San Jose. And those, like the USPTO headquarters, have staff on hand to provide you with in-person assistance when we are open. And I apologize, but again, we too, like many of you, are teleworking right now. We have a wealth of videos for those of you who are more visual learners. We do have a wealth of videos that are available on our YouTube channel. Many of these are from past invention conventions that we've had or invention education programs we've had, and cover a wide variety of topics from trademarks to patents to protecting your IP in China. I would also encourage you to sign up for one or all of our subscriptions. Even as an employee, I receive a number of these subscriptions just because it brings to the top of my inbox anything new in intellectual property. Has there been a change in patent fees or trademark fees? That would certainly arrive in my inbox in a patent alert. There's also our Inventors Eye, which is a publication specifically directed to that independent inventor and often has a lot of tips and information. So I definitely encourage you to sign up for our subscriptions. They're available. Just go to the search box and type subscription, and you can sign up for one or all, as many as you would like. Our USPTO events webpage. This month alone, we have 10 classes being offered, and it's the month of December, when we would traditionally all be enjoying holiday gatherings. Each and every month, we have a number of events that are listed, and I will tell you they are all free. Again, this month alone, we have 10 listed, and they are all being conducted virtually. And even if they're being conducted by one of our regional offices outside of the USPTO headquarters, certainly in the virtual environment, you are all welcome to sign up for as many of them as you would like. As I mentioned, we have a great deal of resources for our startups, for those of you who are looking to start and build and grow that business. And we have it broken down again into very digestible bite-sized pieces. Patents for startups, trademarks for startups, startup assistance, current events. Again, that current events has some of our classes that are coming in. Our Inventors Assistance Center. This is for those of you who have filed a patent application or are considering filing a patent application and have questions. Our Inventors Assistance Center is staffed by retired primary and supervisory patent examiners, so people who have a lifetime of experience, a wealth of experience in patents. No question is too silly. No, in fact, no question is silly, and they love to get your calls. These individuals are dedicated to helping people walk through the process. We similarly have a Trademark Assistance Center, which is open every Monday through Friday, 8:30 to 8. And these individuals welcome answering your questions with respect to trademarks. I want to be sure to highlight our USPTO Patent Pro Bono program. And this is something that was a result of the 2011 America Invents Act. Congress urged the US Patent and Trademark Office to work with legal organizations across the country to stand up pro bono programs such that no inventions were left on the kitchen table or the garage workbench because an inventor was under financially resourced. So we have coverage now in all 50 states. Now, in order to participate, one must apply to the particular program in your area. Now, some programs outside of your local area also take individuals if they're under enrolled, but start with a program that's in your area. Now, you do have to meet certain criteria, and you can see those that are listed here. Importantly, have an income of 300% below the federal poverty guidelines, demonstrate a knowledge of the patent system. How does one do that? Well, you can do that by filing your own provisional patent application or by taking a course that's on our website and completing that online course. Have an application pre-screened to make sure that it's more than a mere idea. And this is because these resources are limited. We want to make sure that these resources are being used for individuals such as yourself who are going to start and build and grow a business that's going to develop into an industry perhaps someday, and to employ others and create jobs. So the patent pro bono program isn't designed for that individual who just wants to hang their patent on their wall. Not that there's anything wrong with that, but that's not what these resources are intended for. As I said, there are patent pro bono programs that cover the entirety of the nation, all of the 50 states. We also have a law school clinic certification program where a number of law schools across the nation, and many in our area, as you can see, participate in providing free legal services through the use of a law school student who is supervised by a registered practitioner or professor. And this is another opportunity for free or reduced cost legal services, perhaps especially if you don't qualify for the pro bono program that I just mentioned. We also have patent and trademark resource centers. What these are publicly available libraries that are located across the nation. As you can see, we have over 80 located across the nation. And they have one or more librarian who is designated as a PTRC librarian and who can help you set up a good quality patent or trademark search. As I mentioned with respect to trademarks, and it's certainly true in patents as well, you are not required to conduct your own search before applying for a patent or trademark. However, my word of caution, my personal word to you would be to strongly encourage you to do so. Because as I said before, your idea may be just so great that somebody's already thought of it. So why not save yourself the headache, the heartache, and the financial outlay by doing a good quality search before filing an application? It also gives you the opportunity to figure out how to perhaps modify your invention or your trademark registration to not interfere with someone that already exists in that space. Last but not least, I just want to mention, as I said, on that toolbar, we do have our COVID Response and Resource Center. There's a great deal of information there about patent and licensing, innovation incentives, all of our programs that are related to the COVID-19 response are featured here. With that, as I said, I promised that I would leave you with my email address. I'll leave you with that phone number. Actually, let me give you a different phone number. Our Eastern Regional Outreach Office phone number is 571-272-7100. That's 571-272-7100. Now this number will certainly get you there, but it'll just take some routing. So please go directly to the Eastern Regional Outreach Office. With that, I am going to stop sharing. And we will return and we will have time for questions. I hope there's some great questions. I hope it's not because I've explained things too poorly, but I hope it's that you've just gotten really excited about what you've heard and you want to learn more.
Yeah, we do have some questions in the Q&A box, so we'll start going down the list here. We had a couple questions about the best way to protect the name of their business.
Okay. So again, that would be through a trademark, because again, the trademark is going to be the indicator of the goods and services. So that is going to be your brand. So that's going to be through a federally registered trademark. Again, as I mentioned, Craig's going to talk about the difference between a common law trademark, which one can do without filing with the U.S. Patent and Trademark Office. But if you want to have a registration that is going to protect you across the nation, then you want the federally registered trademark. So I would strongly encourage seeking a trademark.
Do you sometimes have to get a copyright and trademark for some things such as slogans?
So it depends. It depends on what you intend to use that for. So the question is a great one because the question goes to, there are multiple types of intellectual property and can they overlap? So they each protect something very different, but you may, as a business, be looking to create an intellectual property portfolio. And this portfolio may be made up of patents, trademarks, trade secrets, and copyrights, which all protect very different things of value within your business. So you may have a trademark that is protecting, again, the source of the goods and services, that is protecting the name of your business, and it may be protecting the name of a product, but you may also copyright that slogan if that slogan is then going to be used in some other fashion other than serving as an indicator of goods or services.
Is there ever problems between a registered business name and a trademark where the same phrase is used? And if so, what do you do to avoid that?
So there certainly could be. And this is where, again, I think it's going to be important for people when selecting a name, whether it's a name for a product or a name for their business, to do a search, to do a good trademark search, a good quality trademark search, to know if somebody else is already using that. And if so, is there going to be a likelihood of confusion? So I think before, calling out and investing in, something as your brand, you want to be sure that others aren't already working in that space, because it could just create a lot of problems for you in the long run.
How do you go about selecting an affordable patent lawyer, and what are important aspects to look for?
That's a great question. These are all great questions, I should say. So as I said in my remarks, if applying for a patent, many of you will probably choose to use a patent attorney or a patent agent. And it is strongly encouraged, although it is not required by law. I would strongly suggest that you find someone that you are first and foremost comfortable with. We have a registered list on our website. It's searchable by state, and it's also searchable by name. So you can find someone who's in your local area. But I would suggest when you meet with a patent attorney or a patent agent, and let me step back to say, a patent agent is someone who has passed the USPTO certification exam and has a degree in one of the recognized sciences. However, they are not an attorney. A patent attorney also has a degree in one of the recognized sciences, has passed our certification exam, but also has a law degree. Now, patent agents can do nearly everything a patent attorney can do, except represent you in court. So if somebody infringes upon your patent and you have to go to court, or somebody tries to invalidate your patent and you have to go to court, you're going to need a patent attorney. I only bring that up because sometimes a patent agent can be less expensive than a patent attorney. Now, many law firms employ both patent attorneys and patent agents. There is an association of patent agents, and you can find one through the Association of Patent Agents, or you can also, again, both of these entities, patent agents and patent attorneys, are registered on our website because they have to pass a certification exam that they understand and appreciate both the patent rules and laws, and that they followed our code of ethics. So back to the more pointed question, how to find one. First and foremost, find someone you're comfortable. Find someone who believes in you and believes in your idea. Also find somebody who is well-versed in your technology. I'm not sure that I would necessarily recommend someone who has a degree in mechanical engineering if you have just invented a complex database. You might want someone who has a more targeted background in your area of technology. That's not to say that patent attorneys can't work across technology areas, whether it's mechanical, electrical, chemical, but again, find somebody who believes in you, believes in your technology, and has the resources and ability. Now, one way you may be able to save yourself money is by being that educated consumer. And this is where I encourage you, again, to attend these type of classes, to visit our website, because some law firms, some patent attorneys will allow you to help in the prosecution. Perhaps you can do the drawings yourself. Perhaps you have draftsman skills and you can help prepare the drawings for the application. Perhaps you can do a first draft of a specification by really writing a concise summary of what your invention is. Some attorneys will let you work with them to reduce the costs. Again, patent law firms come in all shapes and sizes. there's small firms, there's big firms. You need to find the one that's the right fit for you. And I'll give you a quick anecdotal story. I don't want us to run out of time, but Sarah Blakely tells the story. Sarah Blakely, the founder of Spanx, who doesn't love Sarah? Sarah tells the story about trying to find her first patent attorney for her first shapewear garment, and how she went to attorney after attorney, and they didn't believe in her. They didn't believe in her product. And they just said, oh, you've cut the feet off of pantyhose. What's the big deal? Well, no, she hadn't just cut the feet off of pantyhose. She had, in fact, invented a new product, and she was able to patent that new invention. And we know where she is today. She's perhaps one of the wealthiest business owners in America. And she has a number of patents in her name. So find somebody who believes in you.
All right, we have another one. Based on your example of the Big Mac, does this mean that a trademark name does not need to be the same as your company name? Can you have multiple trademarks under one company name and legal structure, LLC?
So you certainly can, and that's a very savvy question. You know, if you were to look online and see the greatest brand holders, the trademarks of the greatest value, you'll see there are companies like Coca-Cola, McDonald's, Google, Apple, and you think about each of those companies, think about the product lines that are underneath them. They have hundreds, sometimes even perhaps thousands of trademarks, because they look to protect each of their product with its own separate and distinct brand. You know, when you, again, using our example of the Big Mac, when I go into McDonald's, you know, I have many choices. I have the McFillet of fish, I have the McRib, and that allows me to differentiate the products, but all with under the umbrella of trademark of McDonald's. So no, to diversify and to have those multiple lines of trademarks, again, just identifies the different goods and services that are identified from that particular source. So no, it's a great question. And yes, depending on what it is you're doing, you may have multiple trademarks.
All right. Does the Patent and Trademark Office utilize subject matter experts to review the application for the type of patent? For example, someone with artificial intelligence background in aerospace for a new process not used in aerospace today.
That's a great question, and particularly weaving in the artificial intelligence. So artificial intelligence is actually something else that we have on that toolbar on our website, and you'll see the applications involving artificial intelligence have multiplied over 100%. Now it's probably odd to not find a patent application that doesn't have some form of artificial intelligence in it. So no, the question is, do we have subject matter experts? We do. So when we hire our patent examiners, they are hired because of their recognized technology background. And we have over 8,000 US patent examiners that are trained in one of the sciences, or trained to be a design examiner, or trained to be a business methods examiner. So no, your application is routed. So interestingly enough, talking about artificial intelligence, we are now, in fact, as an agency, starting to use artificial intelligence with how we assign our applications to our patent examiners to make sure they are best routed to the examiner who is best suited to examine them. So there's artificial coming in the patent applications, and it's being used within to direct the examination of patent applications to people who are the best suited to do that.
All right, we're right at 9:59. I think you think we can answer one more question.
Sure, I'll try and keep it short.
Okay. How much detail is required for provisional? Do I need to provide diagrams, code examples, cite regulatory requirements met?
So given that we're almost out of time, I'm going to push that question to Friday to Blake, and Blake's going to talk a lot about provisional patent applications and non-provisional patent applications. And it's an interesting question, because there are a couple of different schools of thought on the provisional patent application. How much should be disclosed? And again, I'm going to defer that to Blake, but I would want to make sure, I'll just leave as a soundbite, I would want to make sure that that provisional patent application is as thorough as possible, because it's going to create the foundation for your non-provisional. So you're not just going to throw in a sketch on the back of a napkin. Make it a good job and make it thorough. It'll help you in the long run.